A very good morning, everybody, or afternoon, wherever you may be joining us from in the world, and welcome to this construction webinar. And in this webinar, we're going to look at COVID-19 from a Saudi perspective, and this will be the first of a series of Saudi law-related webinars from a construction viewpoint that we're going to roll out over the next 6 months, and so please stay tuned for further details. But as I say, this webinar looks at COVID-19 from a Saudi perspective, and we'll look at it from both a contracting and also a Saudi jurisprudence perspective. And in terms of introductions and to kick things off, my name is Ewan Lloyd. I'm a specialist construction lawyer with a particular focus on Saudi, and I'm very pleased to be joined by my two colleagues who are both sitting in Riyadh, Mr. Imad Salama and Mr. Francis Patalong. And Imad is a litigation partner in Saudi, has got a great deal of Saudi law experience, and likewise Francis is a very experienced Saudi law practitioner. And so, as you can probably imagine, today's topic is potentially incredibly broad. And when we discussed how best to present this seminar or this webinar, I think we agreed we probably had enough information to or materials to speak for several hours. But given the limited time available, what we've decided to do is to divide it into two parts. And the first part, which I'll take care of, will look at the COVID situation from a typical Saudi contracting perspective. I'll then pass the floor to my colleagues in Riyadh, and Imad and Francis will discuss the COVID-19 situation from an underlying Saudi and Sharia perspective, and also discuss how the courts have been looking at the pandemic. And then we'll conclude matters with a Q&A session. And so I think you should all have a facility to actually pose questions. So if a question does occur to you as we are going through the webinar, please pose that question, and we'll try to address as many of the questions as we can at the end of the session. And so if we just move on to the next slide, please. The next slide, please. So yeah, so let me start with the contractual side of things. And before we get into the contract and how COVID type situations looked at from a typical Saudi contracting perspective, I think it's important to take a step back and look at how kind of COVID type issues have manifested themselves from a construction perspective. And fundamentally, a COVID-19 type situation lends itself to a construction claim event, and in essence, that comes down to time or money or potentially both. So I thought it'd be useful just to give a few live examples of some of the COVID type situations that we've encountered over the past 18 months or so. And as you can imagine, we all of us presenting today have come across many COVID type scenarios, and so we can probably draw on quite a few examples to give some real some real context to the discussion. And so in terms of some examples of the impact of COVID-19, I put down a few bullet points, and the first is loss of productivity, and I can maybe provide a little more detail around this. So this is in the context of a significant high-rise tower development that we're advising on. And before the pandemic hit, it was possible to accommodate 20 workers per elevator, but on account of social distancing, the numbers that could actually be in the elevator were dramatically reduced to 6. And so, as you can imagine, if you've got a major tall building project, and you've really got the ease or with which workers can actually access the various floors is significantly curtailed, that's going to have a fairly significant impact on productivity and cause delays. Also, in the context of social distancing, of course, they've come with increased costs. And so, for example, prior to the onset of COVID-19, it was possible to transport workers to and from site in full buses, so with a capacity of, say, 80. But because of social distancing, these numbers have been decreased to 40 per bus. That's the cost impact. Likewise, in terms of accommodation, it's no longer possible for people to be in such close proximity as was previously the case. That's resulted in contractors and various stakeholders in the industry having to invest in more accommodation. That comes at a cost. And then the other key issue is probably a supply chain type scenario. So although throughout the pandemic, construction sites in Saudi primarily remained open, that wasn't the case for, say, manufacturing facilities, whether in Saudi or in other parts of the world. And so, for example, we've been involved in situations where manufacturers of long lead items had to close down their manufacturing activities for significant amounts of time, and of course that's had an impact on progress and on progress on the construction projects. And so that kind of probably gives a little bit of a snapshot as to some of the impact that COVID-19 has had. But then from a contractual perspective, it's very important to actually frame any COVID type claim in the context of the contract, and I suppose to kind of go back to basic principles. The principle of freedom of contract does prevail in Saudi. So the contract is a constitution that governs the relationship between the parties, and as may be supplemented by laws, or if the contract doesn't actually address a particular scenario or is silent on a COVID type situation, then the law will step in, and Frank and Francis will discuss this angle. But then, first things first, before getting into the substance of a claim, the first thing to look at is the contractual claims procedure. And in this part of the session, and for convenience, I'll be benchmarking this discussion against a FIDIC form of contract, which are commonly used in the industry in Saudi. And so typically, if you look at a FIDIC form of contract, and specifically FIDIC 99 Red Book as an example, clause 20.1 says if you're a contractor and you believe that you're entitled to relief under the contract, then you're required to notify the employer of that, or the employer or the engineer of that event within 28 days. And if you fail to do so, a time bar applies and you're no longer entitled to bring a claim. And then the clause then proceeds to say, after the initial notification, it is then incumbent upon the contractor to give updates as to the impact of this event until the true consequences can be ascertained. And that really does demonstrate the requirement for the contractor or the party seeking relief to establish causation. And although this isn't a standard FIDIC provision, a second time bar sometimes applies if detailed substantiation is not given within a certain period of time. And so I just want to kind of pause briefly on the time bar issue, because the time bar issue does come up fairly frequently. And we come across arguments as to whether or not time bars are valid, and so sometimes we come across the proposition that time bars shouldn't be considered because they offend underlying Sharia principles. We also come across the argument that although a contractor may not have formally notified the employer of a delay or of a relief event, the employer nevertheless had constructive knowledge of that. And we also come across the proposition that, okay, maybe the employer wasn't actually notified, but did he actually suffer any prejudice? Was his position disadvantaged? And all these arguments they have got their merits, but fundamentally, as I said at the start, the contract is the constitution which governs the relationship between the parties. And our advice is that the contract is always adhered to. And if you do adhere to the contractual claims procedure, you've then got a relatively straightforward route into then looking at the substance of your claim. Next slide, please. So moving on, and assuming that the procedural aspects have been satisfied, and if you are a contractor or a consultant looking for relief, it's then important to work out how best to present your claim, and how should you formulate that in terms of establishing contractual entitlement. And of course, every contract is different. It has to be looked at on its individual merits. But I've set out on the slides 3 fairly typical contractual bases for relief to be sought. And I think when the pandemic first took hold 18 months ago, the natural reaction was to characterize COVID-19 as a force majeure event. And in some ways it may be a force majeure event, but sometimes it's not that simple. And I say that because force majeure is typically based on the concept of impossibility. But then the question then arises, is it actually impossible, or was it impossible for the contractor to perform? Or was it that performance became more difficult, it became slower, or became more expensive, but it was nevertheless still possible to perform? And if performance is still possible, that goes against the premise that force majeure has been activated. And then I think the other point to note is, if you are a contractor and you are looking for relief, you're looking for the most preferential form of relief from your perspective. And typically force majeure clauses provide extension of times, but may not provide costs. So the extension of time will give you a defense against a delayed damages claim, but it may not compensate you for the costs you've actually incurred on account of a COVID type event. And so other contractual bases for relief may be more appropriate. And so if you're going back to my example of a FIDIC contract, FIDIC 99 contract, change in law could be an option. And so under an amended form of FIDIC contract, you've got relief for a change in law in respect to both time and money. So that could be a better avenue for a contractor to maybe seek relief. But then, of course, the drafting of that clause has to be looked at in detail. And although the various measures which were implemented in Saudi to address and to contain the impact of COVID-19 generally satisfy a definition of law, some contracts limit that definition to the laws of Saudi Arabia. And that's fine if the project is just in Saudi Arabia. But frequently, particularly with the bigger projects, there's a fairly significant interface with other jurisdictions. And so, for example, long lead items may be being manufactured in, say, China or Italy or Germany, and maybe the governments in China, Italy, or Germany bring in restrictions. They change their laws, which cease production, and so a change in law in China wouldn't be a change in law, wouldn't activate a change in law regime which just applies to Saudi law, and so that may restrict certain categories of claim. And a connected point is that many subcontracts that we come across are drafted on a strict back-to-back basis, and they've got equivalent relief provisions. And so if you are a subcontractor, you may only be entitled to relief if the main contractor is entitled to relief and actually obtains relief under the main contract. But if you're a subcontractor with a supply chain in China, you may be caught by any kind of jurisdictional limits which apply to the definition of law. So there may be issues trying to get relief from a change in law clause. And so it's another typical avenue for relief would be to look at the contractually agreed extension of time regime. And extension of time regimes tend to be negotiated on a case-by-case basis. So it's important they are looked at on their individual merits. But a couple of fairly promising avenues are that, going back to the FIDIC example I've been using, is that the FIDIC 99 Red Book provides an extension of time if there are shortages of manpower or material on account of epidemic or on account of government action. And although I'm sure this isn't the case, obviously if this ground for relief was drafted with COVID-19 in mind, so that could be a fairly convenient hook upon which to bring a COVID claim. Similarly, we've come across some fairly generous relief regimes for extension of time. So, for example, some contracts we've seen recently give the contractor and the consultant relief for events which are beyond the control of that contractor or consultant. So that's a fairly generous and wide-ranging extension of time regime, which could be used to justify a claim arising out of COVID-19. But of course, establishing a possible contractual basis to claim relief is only part of the story. And I think a further extremely important issue and requirement is for the party seeking relief, i.e. the contractor or a consultant, to actually establish clearly how this COVID event has actually impacted on its performance under the contract. So it's incumbent upon the party seeking relief to demonstrate causation and to show how it was delayed or incurred additional cost on account of a COVID-19 event, which falls within a contractual basis to bring a claim. And look, as I said at the start of the session, we've seen plenty of COVID-19 type claims over the past 18 months. Some claims are a lot more compelling than others, and we come across some claims from contractors who appear to have characterized COVID-19 as almost a silver bullet, which somehow absolves them from all liability and responsibility that they may have under the contract, and haven't actually demonstrated how the COVID-19 event has actually caused them specifically to be delayed or to incur additional costs. And claims of that nature fail because the necessary burden of proof has not been discharged. And then I think the other important point to note as well is that of mitigation, and the fact that anybody seeking relief has to be proactive. It's not a case of saying, well, I've been delayed on account of a COVID-19 type issue, I've incurred additional cost. It's then important to actually show that you have been proactive, you've looked for workaround solutions. And so, for example, going back to the example of long lead items being delayed on account of, say, a factory closure in Germany, I think it's important for a contractor to then look at alternative sources. So, for example, is it possible to procure an equivalent item from a local manufacturer? And okay, there may be differences in terms of specification, maybe differences in terms of cost, but then it's important to at least give the employer that option. And if the employer wants to go with that alternative option, then that could be looked at, and possibly that could trigger a variation. But it is important to show how a party seeking relief has been proactive and has sought to mitigate the impact of the relief event. And if you could move to the next slide, please. So in this slide, I just want to kind of touch on how the COVID landscape has been evolving from a contractual perspective. And of course, when COVID hit 18 months ago, nobody anticipated COVID, and so the contracts didn't deal with COVID specifically. So COVID type issues had to fit in around existing contractual regimes. But over the past, I'd say, 6 to 8 months, we've seen an increase of specific COVID-focused clauses in construction-related contracts. And these clauses look at relief from look at the COVID risk from different perspectives. And so, for example, at one end of the spectrum, we've seen quite a few clauses which say that there's no relief on account of any COVID-related claim, and the justification for that is that COVID-19 is now been with us for 18 months, so it's therefore a known quantity. And on that basis, contractors, consultants are aware of the issues. They should be able to take into account the COVID type scenarios and address them. But I don't think the situation is that clear or that straightforward, because in many ways COVID-19 is very much an evolving issue. It's a moving target. So for example, although we all are aware of the kind of COVID-19 measures which can be implemented, their implementation very much depend on the severity of the prevailing COVID-19 circumstance. And so, for example, if the vaccines are working successfully, which would be absolutely fantastic, and measures can be reduced, then COVID may not be so much of an issue. But then, if, for example, there are different variants which come to the fore, that may necessitate further restrictions to be brought in. I think it's very difficult to expect a contractor or a service provider to anticipate and to price for these eventualities. And so, although we do see these clauses, what we see more commonly is a regime which states there's no relief for existing COVID-19 measures, but then there is potentially relief for new COVID measures which are subsequently introduced. And this takes into account the fact that COVID-19 is very much a moving target. And then the actual relief which is available, it can be subject to certain thresholds, and so we do see foreseeability thresholds built in. Sometimes we don't, and also the form of compensation or relief which is available does vary. So more often than not, the contract only provides for time. We have seen provision being made for costs being made available in addition to time relief. But have been a few notable add-ons which have been brought in the context of COVID. And so we've seen a few clauses, and these clauses are becoming more commonplace. So the right for the employer to descope or to terminate the contract in the event that a COVID-19 event hits. And I think it's important for these clauses to be carefully negotiated and to be looked at in the context. And so, typically we wouldn't advise there to be a blanket right to descope or to terminate. Typically, there should be some materiality threshold which has to be satisfied in terms of severity, and also the consequences of any such right to descope and or to terminate have to be carefully considered, because some regimes just provide for the contractor or the service provider to be paid to demobilize and to be paid for the work, the services they perform. But I think it's important that the contractor or service provider carefully considers their actual true out-of-pocket type expenses or losses that they may incur. So there may be, for example, unamortized costs which may not be recoverable straight away. So I think it's very important that any COVID type relief regimes are carefully considered and carefully negotiated on a case-by-case basis. And so this concludes my very quick snapshot of the contractual landscape from a COVID perspective. I'll now pass the floor to my colleagues in Riyadh, Francis and Ahmad, who will now look at the COVID situation through a Saudi Sharia lens and court perspective.
Thanks, Ewan. I can't believe it's been 18 months. You said that a couple of times, and it's been a very, very difficult and testing 18 months for everybody involved here. I mean, I think picking up on a couple of your observations, the position legally, I think, is still developing. It's quite a fluid and dynamic situation. And as Ewan said at the outset, when we were discussing what we would talk about today, given the wealth of subject matter, we decided to tell you our story in Saudi Arabia, I suppose, and that will tie into a lot of the established contractual principles that Ewan has really helpfully, I think, laid out. So what did we do? What was our story here? And Ahmad will step in and correct me if I miss anything or what have you. Well, at the outset, we were very, very concerned, obviously from an operational perspective, but also with client interests. At the outset of the pandemic, there was a blizzard of legal commentary, I suppose, in relation to COVID-19 and its relationship with force majeure and so on and so forth. And being in Saudi Arabia, what with it being a fairly unique jurisdiction as regards to the Sharia principles on which it's founded, our approach was really to go back to first principles, which was an interesting exercise because the sources of Saudi law are drawn from various sources, including the Quran, Hadith, as well as laws that have been promulgated by the government. So we spent our time over the summer last year looking at Arabic source materials. And the result of that was an article in our legal periodical Law Update in Arabic and then in English. And that was a fairly comprehensive overview of the various strands and sources of dealing with exceptional circumstances and force majeure, having regard to Sharia principles and relevant laws. And it's fair to say, I think, that there wasn't a single magic bullet in any law addressing force majeure. It's quite an eclectic mix of laws. However, underpinning it all, there were certain Sharia principles which everybody needs to be mindful of when we're addressing these contractual issues in Saudi Arabia. So what we put out, I think it was August last year, there's a link in the slides to the English version, which we'd be delighted to go and look at, but it's been superseded, as you'll see, by what happened subsequently. Was more than informed guesswork. You know, we spent some time and care crafting a very, very careful article in relation to that. And it's fair to say, I think, Ahmad, that it became a reference for lots of people in terms of how they were looking at COVID. So next slide, please. Just some very, very high-level remarks on the character of the Saudi legal system. Apologies for those of you who are familiar with this. There are certain givens here, as I've already signposted. The principles of Sharia are drawn from various texts, the Quran, Hadith, and Islamic jurisprudential sources. They're very, very important. Saudi Arabia is a Sharia jurisdiction. There are various axioms that you cannot avoid, and you'll hear, and sometimes they can come into somewhat of a conflict. So one of the key principles that you often hear, and Ewan signposted this in his remarks on how you conduct the claim processes, the contract is the law of the parties. So it's axiomatic as a matter of Sharia law that unless something is expressly haram or forbidden, and the classic example of that would be interest, then it's permitted. And you have great freedom of contract, which means that you need to look very, very carefully at your contract obligations and make sure that you adhere to them scrupulously. Having said that, there's also the concept that conduct is important. And what Sharia judges will look at is the conduct of the parties and the balance of interests. So it's axiomatic as well in terms of the conduct of disputes under Sharia, that you give the party in default an opportunity to remedy its default. The objective here is to achieve some form of equity or justice, and that's certainly something that each Sharia judge will take into consideration. They're not bound by precedent. They stand alone. They apply Sharia as it fits the facts that are being presented to them. Case reporting is patchy, shall we say, and because of the nature of what's happened with COVID, there isn't a huge amount of reportage out there, and I anticipate that's because quite a lot of the conversations that have been had around the issue are confidential. So next slide, please. This is what we concluded. This is a kind of boiled down synopsis of where we got to in terms of our analysis of Sharia. And this would apply to any set of given facts, and clearly to COVID-19. And there are two driving principles here. Circumstances change in a way that materially increases the burden of one party, and the change in circumstances is not caused by negligence. Then the judge has authority to step into the contract, rebalance the obligations, set aside the contract entirely, or grant some form of short-lived grace period or other relief. So the Sharia judge already had a high level of discretion and ability to apply his wisdom based on the facts and the conduct of any particular case. Now, what made it exceptionally interesting to advise in these circumstances was at the get-go, we had a series of these sorts of cases. And the advice was based on Sharia principles. We've gone back and we looked at those principles. But what happened subsequently, and it was in January of this year, is that the authorities in Saudi Arabia had taken a step back as well. And they'd looked at what was going on. They'd looked at trying to be helpful and issue a framework under which the Sharia judges could apply their minds to the particular issues driven by the pandemic. And what eventuated ultimately was a decision from the Supreme Court, which Imad is going to take you through.
Yeah. Thank you, Francis. Thank you, Ewan. As you mentioned, Francis, the competent Saudi authorities since the early stage of the pandemic, they were like watching the circumstances, the situation, and assessing the impact carefully, and based on that, and according to the general principles of Sharia, they issued several decisions, starting from a royal order addressed to the Chief Justice of the Supreme Court, referring to the Bureau of Experts' opinion, and based on that, the Supreme Court. So next slide, please.
Next slide.
Yeah.
Sorry.
So as I mentioned, this royal order referred to the Bureau of Expert opinion for the General Assembly of the Supreme Court to consider several issues related to the pandemic and the impact. And the first one is the adoption of the legal principles on aspect related to COVID-19 pandemic and the impact of force majeure and exceptional circumstances on the affected contract and the assessment of such impact, and also recommending to address the limits on courts powers to amend the obligations of both parties and the contracts. And in light of that opinion, the Supreme Court issued a decision highlighting some principles and providing some conditions when applying these principles. So we'll go we'll take you through these the most important and relevant principles and conditions. Next slide, please. So in the Supreme Court decision, the court made it explicitly clear, and they differentiated between the exceptional circumstances and the force majeure. So the COVID-19, they consider the COVID-19 pandemic as an exceptional circumstances if the obligation or contract cannot be performed without an unusual loss. And for the force majeure, if, as Yuan highlighted, if performance become impossible. But applying this principle is subject to several conditions that need to be satisfied. Next slide, please. So the application of this principle is subject to the following conditions. The first one is that the contract was concluded before the commencement of the COVID-19 preventive measures and continued to be performed in the wake of the pandemic, and the impact on the contract is direct and unavoidable, and the impact on the contract was caused solely by the pandemic, and there is no contributory cause. Also, the affected person has not waived or reached settlement. And the last condition is that the effects of the pandemic and its damage are not addressed by a special regime or a decision of the competent authority.
I think it's fair to say, Ahmad, isn't it, that this concept of contributory cause has kept us quite busy over the summer, because, and it goes to one of the questions that have been asked by the audience in terms of how you substantiate force majeure COVID type claims. Unwinding what you can attribute to the pandemic and what would have happened in the ordinary course is very, 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 very challenging. And it's one of the things that we'll touch on a bit later when we start talking about the role of experts, I think, in particular. Anyway, sorry, carry on.
And within the Supreme Court decision, they covered several types of contracts, and one of these contracts that they dealt with is the construction contract, which my Francis may highlight on. Next slide, please.
Next slide, please. I think it's probably a fair observation that this decision came out in January, which isn't that long ago in legal terms. So how this has been tested in earnest and applied by the courts is an ongoing process. As we said at the outset earlier, there was a Sharia position, and what the Supreme Court decision does is it provides some tramlines around what may or may not be awarded. How parties are building their arguments to advance their case or defend their case, it's still very much, I think, a work in progress. So we've picked out in this slide some of the salient provisions of the decision. And as Ewan indicated at the outset as well, it really does drive into the detail of increases in cost materials. The allocation of risk, I think, is an interesting question here, because the classic allocation of risk, for example, on a project would be to allocate the risk to the party who's best able to manage it in the interest of economic efficiency. That's one sort of benchmark that you have out there. Or with something like this, how do you affect that? So you know, it really does indicate to us, and we've seen this in advising clients, you need to be very, very disciplined and astute in terms of managing your information and your records and being honest, actually. You know, I think Ewan mentioned earlier that at the outset, you know, COVID was potentially viewed as a kind of silver bullet that would be used as a blanket. It won't be. You know, it's going to be subject to a great level of scrutiny. You know, you're going to have to go some hard yards to convince the judge, particularly given this court decision. So next slide, please. This is another selection of some of the more interesting elements of that decision, and it relates to penalty clauses or fines. And again, we've advised extensively on that, and part of the challenge has been sort of disaggregating what were breaches from what were legitimate excuses, supervening events related to the pandemic. I think Ewan gave the example of something as ostensibly simple as health and safety measures with how many people can get into a lift. You know, I mean, that is quite a granular level of detail, but if that had an impact on your ability to deliver on time and you failed and you got hit with a delay penalty, then you need to be able to show that that was what caused it. And, you know, the cardinal principles we've highlighted in red here is that the defaulting party has a burden of proof that its default was due to force majeure. So, you know, what the decision does to our mind is it throws quite a lot of hurdles around the Sharia position, but is nonetheless consistent with the Sharia position. And if you actually look at the decision in the preamble to it, it does invoke all of those Sharia sources. I mean, there's a huge amount to drill into here, so please do pepper us with questions. Just going to move on quickly to some concluding remarks, and then Imad's going to tell you about another relevant development, which we think this would be incomplete without mentioning. So next slide, please. So we've told you what our sort of COVID-19 journey was in Saudi Arabia. We're still on that journey, I think. You've got the original Sharia position, you've got the position of the Supreme Court decision. I go back and say there's still no concept of binding precedent. I reinforce the notion that the judges have discretion, actually an obligation to apply Sharia. The decision does provide some tram lines, and what we've done with a number of clients is we've sort of extracted the relevant elements of that as a kind of SWOT analysis tool, so that they can try and determine, you know, how realistic their COVID position is if they want to advance it, what their contributory cause position is, because nobody wants to embark on any kind of dispute resolution procedure if you haven't got a strong position. So I think what the Supreme Court decision does do is it gives some very, very good conceptual framework to assess your position. Final word. I mean, obviously, amicable resolution is ideal, but clearly, you know, people are going to be looking across the continuum of contracts that they've got. They're going to want to make sure that, you know, what they do with one counterparty is not setting a precedent and so on. So we're in a very interesting stage, I would suggest, of the whole COVID dynamic at the moment. But the final point, I think, is the role of experts here. It is highly likely, I think I could say highly likely, that a Sharia judge will invoke an expert opinion, and the parties should have a role in being able to determine who that is. But if they can't, then the court will appoint one. And that goes to what we were saying, building on Ewan's very, very detailed exposition of typical force majeure type processes, that you need to be very, very good at recording what you've done, what the conduct of your parties were, how you attempted to work around, what the considerations were. I think, as Ewan's already signalled, it may be that there's a law or regulation in another jurisdiction that has some relevance here. You need to be building your case, and likewise your rational defence position, because an expert is likely to be a reference point there. Did you have anything else to conclude? I'm going to hand over to Imad just quickly now, because the new commercial court law, which came out last year, so next slide please, is also, I think, noteworthy in this regard, because it did contain some innovations in relation to time bars.
Yeah, thank you, Francis. So, like so that it is useful to highlight on some important points which like any party or claimant need to consider, which we've seen in recently, that the court is applying. As Francis mentioned, this law was issued last year 2020 and adopted some of the formalities in terms of notice letter and lapse of time, and they are applying these strictly when it comes to filing any claim. So in terms of the notice letter, before filing the case, the court will check, before accepting the case, they will check that if the plaintiff notified the defendant in writing to satisfy exactly the claim at least 15 days prior to initiation of legal proceedings, and if not, they will not accept. And even for any reason they accepted, the court will examine that, and you have, like as plaintiff, to show that this notice letter has been sent and proof of receipt from the other party. Otherwise, they will dismiss the case. This is very important to consider before initiating any legal proceedings. Also, like the law adopted explicitly the lapse of time, which is 5 years from the date of the cause of action, and the executive regulation elaborated in that and differentiated between the rights, raised before the issuance of the law and the rights after, and the time when the 5 years will be counted. So
it's fair to say, isn't it? We're 18 months into this, as Ewan reminded us earlier. 5 years is not a long time in a legal calendar. So that's why we wanted to highlight this particular innovation, which again pops out sort of mid-pandemic.
Yeah.
I think
so,
that's probably it.
This is it.
We've got some questions. I think we're now into Q&A. I'm conscious of timing. Ewan.
That's right, Frank. So we've got about 10 minutes to go, or 9 minutes. We've received some quite interesting questions. So maybe I can just read a couple of these out. Maybe we can discuss our responses. And so, an interesting question is: in our experience, are parties generally cooperating in respect of agreeing COVID-19 related claims? Do you want to kind of jump in there, Imad and Frank, first, and I can give my views?
Well, as we said, I think we're on a continuum here, and our experience, Imad, and please embellish, but at the beginning, everybody wanted to work together cooperatively to try and manage what was a crisis. And over the last maybe 6 months or so, people have begun looking in earnest at their contractual rights, I suppose. And I think the next step is going to be involving contractual organisations and clients looking at these issues across the spectrum of their businesses and developments. So I think we're on a kind of continuum there, which is why I would emphasise the importance of maintaining good documentation, noting what Imad was saying about time bars and so on. So yeah, I mean, I think there has been a will to cooperate. I mean, it's quite interesting. You've got to position these debates in terms of what's in the contract, because as we said, the contract's law of the parties. So there's a rights-based analysis, isn't there? And then there's a kind of interests. There's an interest-based analysis, which is what you tend to draw out through any mediation process and that you might be involved in. It's a different approach. It's looking at interests and trying to mediate a settlement. And that's certainly got to be in the mix here. And it's to be encouraged, frankly, because the sort of rights-based hard contracting position is not ideal. It's not. It is a full-on and expensive legal process. I would say.
I suppose. Sorry, Frank. Yeah, I just suppose I agree with you, Frank. I just say, I suppose my perception is, which aligns with yours. I think when the pandemic first took hold, and it's kind of fairly uncharted territory, in my experience at least, parties did reach some fairly flexible and temporary resolutions and solutions. But as time has passed, I think there's a definite tendency towards parties looking at their respective rights and obligations under the contract and concluding the issue in that way. So I think as time has passed, the whole kind of COVID-19 type claims process has become a lot more contractual than was maybe the case, say, 12 months ago. But I think at the same time, I think there is still a tendency to try to look for commercial solutions, albeit within the confines of contractual entitlements.
Yeah, I mean, it's an interesting question that was asked. There's another one similar from Aya Adam, relating to what's the position if there's some initial relief provided, workaround or what have you, and then subsequently, when we start getting into these harder discussions around rights, further relief is required. And my response to that is really, well, make sure you've recorded everything, because a Sharia judge will, or an arbitrator applying Sharia law, will look at the conduct of the parties. It will be important to see what was reasonable and rational. And as we said, they have broad discretion to rebalance contracts in the interests of justice. Very, very difficult to give anything more precise there, with apologies, but it will be on a case-by-case basis. So I think if you've had initial relief and you're asking for further relief, well, what would the grounds be for that? But we can pick that up do a deeper dive offline if you want. Ewan, were there any other questions that you wanted to?
There have been a few quite interesting questions coming in. I think you probably answered this already, Francis and Ahmad. But one question is if a contract doesn't actually contain a force majeure or COVID type relief clause, can I potentially claim relief under Saudi law? I think you just answered that question, Frank, but maybe you'd like to elaborate slightly.
Yeah, I mean, this is a Sharia jurisdiction. I mean, for any common lawyers on the call, the position is kind of akin to equity, as it would be understood in those sorts of jurisdictions. So it's about fairness. Some of those equitable maxims are good sort of benchmark tools here. So clean hands, using it as a shield, not a sword, those sorts of concepts. The idea is to achieve some sort of justice and balance in contractual relations. So if there isn't anything in the contract, that's not the end of the story. That's right, isn't it?
Yeah. Also, like according to the decision, like although we mentioned that the contract is the law of the party, but still, according to the Supreme Court decision, any clause in the contract operating to exclude either party's liability on account of force majeure, I think this is unforeseeable, and it's clear in the decision. So the decision, is based on general Sharia principles and recognizes that the law, that the contract is the law of the party, but still there is.
And the classic sort of axiomatic Sharia principle there is that you're only entitled to recover actually incurred direct loss, which is quantifiable. So actually incurred, quantifiable direct loss. If there's anything in any contract which cuts across that principle, and it's an interesting conversation around liquidated damages sometimes, it's open to the judge to say, well, no, that's contrary to that particular position. So it does go down to what was the intention, what was reasonable in the circumstances. It's case by case.
And it's key. The other kind of key point as well, which you've well made, Frank, is the key requirement to actually substantiate and demonstrate cause and effect, and have detailed records which really tell a story and establish why you did suffer this delay, why you did suffer or incur this cost. That's imperative, because anybody seeking relief has got the evidential burden of establishing these losses. But I've just looking at the time, I think we're coming up to the hour mark. So I think this is the correct time to conclude this webinar. So I'd like to thank all the attendees very much for their attendance. I'd also like to thank Ahmad and Francis for their excellent contributions. I think it's been very informative. And like I said at the start, this is the first of a series of Saudi construction law related webinars, which we will be rolling out through the second half of 2021. So please stay tuned for further events, and I look forward to reconnecting with you all then. Thank you very much and good afternoon.
Thank you all.